Hi, everyone. Thank you so much for joining us for Moore versus United States. My name is Caitlin Marple. I'm Pioneer's Deputy Director of Development. I wanted to start off by thanking Hemingway & Barnes for hosting us today. We're sponsored by Brian Broderick, who is a member of our board, and we're really grateful. So I know a lot of you in the room are familiar with Pioneer and what we do, but for those of you who aren't, welcome. Pioneer is based here in Boston, and we're focused on three key policy areas: K-12 education, the life sciences, and economic opportunity. And almost 2 years ago, in just a few months, we launched Pioneer Public Interest Law Center with our president, Frank Bailey. Active across the New England states, PPILC has a mission that runs in tandem with that of the Institute, focusing on educational choice, economic opportunity, and open and accountable government. So in front of each of you is a copy of the newest edition of our quarterly newsletter, In Brief, which details some of the recent wins and ongoing cases that the Law Center has been working on. Tonight, we're really pleased to be partnering with the Competitive Enterprise Institute to bring you this event, and I'm thankful for our esteemed panelists for joining us. And with that, I'll turn it over to Bob DiCostanzo to tell you a bit more about CEI's work.
Thanks so much, Caitlin. So I'm Bob DiCostanzo. I'm on the philanthropy team at the Competitive Enterprise Institute. CEI is a nonpartisan nonprofit education organization, and we focus primarily on reducing the size and scope of the regulatory state in order for people to have the means to provide for themselves and their families and their communities. We do this in a variety of different ways, traditional think tank stuff, so research, analysis, producing policy publications, but also through relationship building up on the Hill, as well as in state capitals across the country. Traditional media campaigns, as well as social media, so trying to influence public opinion as well as policymakers, and then also strategic litigation as well, which is one of the reasons why we brought Moore versus United States. Really happy to have everyone here. If anyone has any questions about the work that we're doing, feel free to let me know. Be more than happy to have a conversation, and really appreciate this opportunity.
Thanks, Bob. Frank?
All right, great, thank you. So welcome, everyone. And so when they asked me to moderate this panel, and they said it was about the code, I said, well, I know that code, but it turns out that's the bankruptcy code, not the tax code. So I'm going to do my best. It's a fascinating case. But let me introduce my fellow panelists for this program tonight. Kent Lassman is the president and CEO of CEI, which has just been introduced to you. I would read the little bio he sent me. It's not typical, where he says that he's an optimist by nature and a Virginian by choice, and is an outdoors at every opportunity. Proved that to me tonight, because our kids went to the same camp up in Rangeley, Maine, and my wife and I would pick our kids up and get out of town fast because we didn't like being out of doors. But it sounds like Kent and his wife go up there and stay for a week. So I'm delighted to be here presenting with Kent this afternoon. And Thomas Berry, who is happy for us to call him Tommy, is a research fellow at the Cato Institute and at their Center for Constitutional Studies. He's the editor-in-chief of the Cato Supreme Court Review. Prior to working at Cato, he clerked in the Fifth Circuit Court of Appeals, Federal Court, for Judge E. Grady Jolly. Yep. Yeah. And he also worked at Pacific Legal Foundation, which is another like-minded entity that we have been doing a lot of work with recently on equity theft issues here at Pioneer. So, and most importantly, Tommy worked with some outside counsel to produce an amicus brief, both at the cert phase of this case in support of granting cert, and also at the merits stage. I did a little slide presentation here. I didn't show these guys, and I just did them this afternoon, so I didn't have time. that's what we're going to try to do today. And I'm going to start with, I think it's really kind of important for you to, let me say this. There were 40 amicus briefs filed in this case, and I looked it up today. And yes, for Dobbs there were 120, and for a couple of the really high-profile cases there are more. But the number looking back to 2020 and 2021 in that term, the number was only 16. So that tells you something right off the bat. They're in the Moore case. There are 40 amicus briefs out there. These are not inexpensive to produce. They take an awful lot of time and effort, and it has attracted a lot of interest. But I would like to start by asking Kent to introduce us to Charles and Kathleen Moore. Because like most things that we end up doing, it's in some ways an intensely personal story, and I think you ought to meet them. And there's their picture, by the way. So Kent, please.
Thank you, Frank. Charles and Kathleen are not unlike you at all. They're not unlike your neighbors. They are retirees. They live outside of Seattle. They have 3 adult children. The case has its genesis well before the investment at issue that was initiated in 2013. It goes back to the mid-1990s. Charles, there on the right, was a software engineer at Microsoft. And one of his friends and colleagues on the Office Suite project or team was a man named Ravi Agarwal. And Ravi and Charles retired from Microsoft in close proximity to each other in the early 2000s. Yeah. Mid-aughts. Ravi had the idea, both of these men retired relatively young, right, in their late 50s, mid to late 50s. And they had done well, but they were not ready to just sit back and play bocce. Ravi wanted to start a company because he thought he could do something good for people that he knew, that he was familiar with their life back in India, where he was originally from. And his idea for a new company that he thought he could bring to the world, he took to a series of friends. And as it turned out, Charles and Kathleen were the only people who invested, other than Ravi. They put $40,000 of their savings, their retirement savings that they were now living off of, into a new company founded in 2013 called the Kizencraft. And the purpose and mandate of Kizencraft was to develop the market and manufacture and sell hand tools and small power tools for farmers in India, and a very specific class of the market or slice of the market. Ravi was interested in small landholders or people that didn't own their own land. These are borderline subsistence farming, right? And he noticed that not only did they not have access to lots of things that people in America had, but they didn't have the basics that we take for granted, things like steel implements that we get for a couple $dozen at Home Depot. They would be using tools that would break each season, where they would have to share. So he knew there was going to be capital involved. These people were willing to invest. Farming is a very capital intensive business, but he thought he could help lift the entire strata of farming up a level by improving the capital equipment. He launched this firm in 2013, and within 4.5 years, he had hundreds of distributors selling in every state in India. They were selling hundreds of thousands of sales per year. So each sale might have multiple dollars or multiple tours, but hundreds of thousands of individual receipts. And they were changing farming because he was introducing things like shovels and hose and tools that would help with irrigation when the pump was still hand driven. Charles and Kathleen, as I said, they invested $40,000. Their principal interest was they believe in capitalism. They'd been involved and friends of and paying attention to CEI and our work for many years. I'm sure they are involved in other good organizations promoting liberal values. What they didn't know was that down the road in 2017, a tax law would be passed in December that would have a narrow provision targeted at large multinational companies that would end up ensnaring them in that initial investment. So they invested in a company that was privately held. It's not traded on a stock exchange. They invested in a company where they don't have decision rights. They cannot decide whether or not interest is paid or dividends are paid, or they cannot decide whether to pay or to do a stock split or anything of the sort. They invested in a company because they thought that one of the best ways to provide aid was to help people with work. And capitalism was the mechanism that they wanted to work through to provide better work for these Indian farmers. And their story was brought to me at a meeting of an organization called the Mount Pelerin Society. This is an organization that dates to post-war years. First meeting was in Switzerland, surrounded by a series of economists. There were about 36 who met for the first time to try to sort out what they would do with the post-war economy. Friedrich Hayek, Milton Friedman, these guys gathered and sat in a room for several days and argued with each other about what to do. And subsequently, this meeting has been going on annually around the world. And in 2018, Charles walked up to me and he said, "Kent, have I got a story for you?" I said, "Well, tell me about it. But I haven't been to Seattle in a long time. Maybe if it's a great story, I'll come out and see you and we'll do something with your story." And he proceeded to tell me how they had invested money. He was told by his friend Robbie to look into the new tax law that had just passed in December because he didn't know what to make of it. Charles, for the first time, had to hire attorneys. They had to get tax lawyers because Kathleen had always done their finances at the kitchen table. They didn't know what to make of the mandatory repatriation tax, which was one provision in that law. And it turned out that they had to plead to the IRS. We didn't know that we were liable. That's why we didn't pay it. Furthermore, we don't think we should be liable. They had to pay $15,000, $14,800, I think, because the way the IRS works is if you disagree with the IRS ruling, you have to pay them before you're allowed to appeal. So they paid their 2017 tax bill in late 2018. We then took up their case, appealing first at the IRS and moving through the district courts of Washington. The thing that I want to underscore is these people are not the only ones caught up by this tax. They are the only people in America, however, that raised their hand and said, "We will challenge it." And one of the things that we did for almost 11 months, we did research before we filed. This is very common in public interest law. It's I'm sure not uncommon in a firm like this. You don't take every client that walks through the door because you have scarce resources. And you want to make good law when you do public interest law. And we did research to try to figure out why big companies weren't challenging this, why wealthier citizens who maybe had more at stake were not challenging this. Why were we alone? And did we really have this silver bullet of a case that nobody else knew about? And what we came to find out by visiting with people in tax divisions of big law firms, regional law firms around the country, is that everybody knew about the provision. Everybody knew about the problem. And it was just a poorly worded section of the law. But nobody wanted to get on the IRS's radar. Everybody else had bigger stakes and they didn't want to be under the microscope of the IRS. And the part that makes them special is that ultimately they raised their hand and they said, okay, we'll do this because we think it's the right thing.
So I remember when the statute passed, and there was a lot in the press about recapturing these profits that had been earned, by Google and Microsoft and, the other large America's largest companies. And in fact, they do estimate there were about $2 trillion in profits that were nestled abroad. And the intent of the statute was to bring back, repatriate those profits. But it wasn't to repatriate $15,000 from people like this. We're not talking John Deere here, we're talking hose and shovels, right?
Yeah.
They're doing a good thing. And I'm sure it would, it'd be a lot easier for them on time, to pay the 15, as they did, pay the 14,800, not 14,100,000 to pay that money and to move on with their lives. But so at the center of this dispute, Caitlin, the next slide, please. Yeah, it focuses on what has now become my least favorite amendment, the 16th Amendment, which is the income tax. It's the amendment to the Constitution that allowed the income tax. And you need a tutorial on this. I did, and you're going to get one right now. So Tommy, if you would, please, could you give us a little background on a little constitutional history on this amendment?
Yeah, happy to. So before I went to law school, when I'd heard, little I knew about the 16th Amendment, almost everyone describes it as, oh, that's the bill that for the first time allowed a federal income tax. That's the shorthand. For practical purposes, that's correct, but it's a little wonkier than that in a very interesting way. And the key words are without apportionment. So what does that have to do with anything? What does it mean, apportionment? Well, it goes back to a compromise in the original Constitution that's one of the most forgotten compromises. So a lot of the compromises in the original Constitution are famous. Many of them were between small and large states. The most famous one is probably the Senate and the House. The large states wanted more representation. The smaller states wanted equal representation. So that was a compromise. But one that was less well known was a compromise between larger and smaller about the relationship between taxation and representation. Again, the larger states wanted more members of Congress for themselves. But there was also the smaller states, there was concern that they might not sign up for that kind of rule, that they might get railroaded or lose every vote. So someone had the interesting idea, okay, well, what if we tie representation and taxation together so that they go up equally? So we'll put in the original Constitution that not only are representatives, but also the direct taxes taken from your state in proportion to the population of your state. So if you're twice as big as another state, you have twice as many representatives, but you also have to pay twice as much in direct taxes. And there are a few perceived benefits to that. One practicality that we don't think of that much nowadays is just truthfulness in the census. They didn't have as much sophisticated, people going down and knocking on every single door. They relied a lot more on self-reporting. And if being a bigger state was just a pure benefit and had no downsides, it meant more representatives. There was concern that people might cook the books and invent more, kids than they actually had. They thought, okay, this will keep them more honest. If you invented more people than you really have, you'd also be hit with a bigger tax bill overall for your state. And it was also thought that this would be a roughly fair rule of thumb. At the time, everyone was there wasn't, such a wide disparity in rich versus poor types of jobs. People thought, as a rough rule of thumb, if a state has twice as many people, they probably have about twice as much the wealth, twice as much the income, etc. Now, both those assumptions basically very quickly turned out to be not correct. So an easy example I can give today for why this wouldn't really be workable is I can compare Massachusetts and Mississippi. Those are two states that have roughly similar populations. Massachusetts has a vastly larger state GDP. It just has, on average, the per capita income is a lot higher. So if we still had this rule of the original Constitution, Massachusetts and Mississippi, because they have similar populations, would have to overall contribute similar amounts indirect taxes to the federal government, and that would be extremely regressive on a per capita basis. But what is a direct tax? So that was another thing that was not settled. Even at the constitutional debates, in Madison's notes, there's a funny portion where someone says, well, what is a direct tax? And then he just writes, no one answered. So people started, it's more in the early era of the country, it was more defined by what it's not. It was quickly decided that a tariff was not a direct tax. Something like a sales tax, even though we never had a national sales tax. But in general, it's the idea of things like tariffs where you're paying it on the basis of some sort of transaction. You're paying it as part of a particular thing you're doing is indirect. Whereas if it's something where you write a check to the federal government and send it directly to them, that would be a direct tax. So things that it was generally understood to be direct tax would be things like income or appreciation, whether that's income from a job or appreciation from property, et cetera. And the key precedent in the Supreme Court in the early 20th century was a case called Pollock, where the Supreme Court affirmed for the first time explicitly, they struck down a federal law that basically taxed appreciation on property, income, sort of capital gains type law. And they said, no, this counts as, this is a direct tax. It's not apportioned, so therefore we have to strike it down. So at that point, President Taft said, this just isn't workable. The federal government's becoming bigger. We can't get by on just tariffs and indirect taxes. We need a feasible income tax without this apportionment rule that basically is making it impossible to do in practice. And it was the progressive era. It was people were behind that. And so there was enough popular support to get the 16th Amendment passed. And basically ever since then, this original apportionment rule has kind of been lost to history. Most people have forgotten about it. So even today, when we're talking about something like the tax at issue here, the mandatory repatriation tax, it's not that you could never do a tax like this if this is in fact a direct tax. It's that if in fact this does not tax income, which the 16th Amendment creates an exception to, that apportionment rule still applies. And there's no doubt this was not apportioned. There was no attempt to apportion this among the states. So now the interpretive question is about what does this rule income mean? And clearly this is a limited exception to the apportionment rule. They could have written a broader amendment that just said the apportionment rule is gone. Anything, any taxes that go to the federal government now don't need to be apportioned, but they didn't. They wrote it more narrowly. They wrote it explicitly just to overrule that Pollock case that I mentioned, which was about income taxes. And so now the interpretive question in this case comes down to, in the early 20th century, when the 16th Amendment was passed, what did income mean? Because whatever income meant, that's what's exempted from the apportionment rule.
So if you could briefly tell us what this new statute was targeted to do.
Sure. So it's called mandatory repatriation tax, or that's the shorthand. It looks at foreign corporations where a certain subset of them that have certain qualities, essentially Americans own a majority of them, and it looks at Americans who own more than 10%. And it looks at all of the reinvested income that those corporations have had going all the way back to 1986. So basically 30 years. And it says, it's kind of a legal fiction. It says whatever those corporations have earned and not distributed, so not given out in capital gains, dividends, and whatever they've earned and reinvested in themselves, we're going to, on a pro rata basis, tax all the stockholders who own more than 10%, the percentage. So the Moores owned, I think it was like 13 or 14%. So we're going to tax them as 13% of all of Kissinger-Craft's income, potentially going back to 1986. It hasn't existed that long, so going back to when it was created in 2006. Even though the Moores did not own, even if the Moores had not owned it going all the way back there, it still would have taxed them.
Yeah, that's particularly troublesome, isn't it? So you would be taxed on income that was earned before you even owned your stock.
Yep.
So you couldn't possibly have received it. But I'm wondering about this, and I'm a good enough lawyer to ever question or the answer to. And you and I talked about this. So but I think I have this right. Where the heck is Google and Meta and that's Facebook, but where are these giant companies? Why are they not at the Supreme Court after this tax passed?
There's an interesting, there's a simple and a complex answer. The simple answer is rooted in a corollary to what Tommy was telling us about. The Constitution of today, the amended Constitution, has, I believe, two specific protections for taxpayers. This one is the apportionment one we just discussed. This suggests that direct taxes must be apportioned, right? There's also a protection for taxpayers for indirect taxes, and it's different than apportionment. The Constitution calls for them to be uniform, right? Google and Meta and John Deere and whomever else, the Constitution is to protect individuals from government encroachment. So the simple answer is, it's harder for them to bring a constitutional claim. I think the little bit more complex and mildly cynical view is they were for this, right? So if you have a company worth $200 and 110 of it is based in a foreign subsidiary in Ireland, and the government tells you, we will give you favorable tax treatment if you bring part of that 110 home, you want to do that because you will not be paying the high tax rate. You'll be paying the low one-time offer, bring it home now tax rate.
Got it. So our corporate tax in 2017 was about what, 30%? Wasn't it 30%? Corporate income tax. Let's work with that.
I'm gonna work with that, but I'm not gonna say that in front of a bunch of lawyers.
Yeah, let's say it's 30%. I think this statute actually reduced it. But so you could, if you're Meta, you will work with Ireland. I hate to pick on Ireland, but we will. So you've got some billions of dollars,
Billions and billions.
held in Ireland, and you're not bringing it back because in Ireland, your corporate income tax is either zero because they love you, or it's 8%, and here you're gonna pay 30%, so you're.
It was about 3 times higher here.
3 times.
Than the average
everywhere, yeah.
The average of where the money would be coming back from.
So to be clear, then I think you were, but I'll make sure I get it. The part of the statute is we'll let you bring these dollars back into the United States at a lower tax rate over a period of time. That's a helpful thing to Meta or whoever's been.
So the government revenues, they can project, for the next 8 years, we're gonna see these flows of capital. And so we will tax them at 20%, right? So the government revenue goes up. For the corporate balance sheets, they see we have these stranded capital overseas. We can bring that home, put it on our balance sheet at a lower average tax rate. So there's a win on both sides there, but it doesn't account for individuals.
Right.
So the Moors were not met up.
And there are a lot of Moors out there, right? And so, we, as this group, our 3 groups, are, we're worried about the Moors. We're worried about the small businesses that are, we want to incentivize the Moors to make those investments, right? And at least you want them to not get hit with a tax that they didn't plan on. It seems rather unfair, doesn't it? So we'll take a question now.
Can I ask? Oh, I'm sorry, should I wait?
No, go ahead.
Just right on this question. Of course, we have a double taxation system at the corporate level and the shareholder level. So I take it that it doesn't work to shield shareholders from the mandatory repatriation tax if the corporation itself repatriates its overseas earnings, and it pays the lower tax rate than that would otherwise have applied. So at the corporate level, that's a happy outcome. But if it doesn't distribute that repatriated profit from overseas, the shareholders still would have to pay the mandatory repatriation tax? So for example, Google or Alphabet has just declared its first dividend. So let's assume that they repatriated their overseas earnings.
This is a great question about piercing the corporate structure. I'm sorry, did I cut you off? I didn't mean to cut you off. I
So this
think,
would apply only to those who are 10% shareholders. Maybe the answer is for Google and other large companies, you really don't have many 10% plus shareholders.
well, that is true. The foreign subsidiary of Google is what we're talking about. Individuals in America who own 10% threshold.
Right.
There's very few of those, like maybe founders. But at issue, I hesitate to throw compliments around too easily when I'm talking about Congress, but the drafters of the law are clever, right? So it only applied to tax year 2017, right? So if you are a large firm of any sort, services, manufacturing, software, what have you, you can plan to bring home capital over the course of a scheduled number of years, but it's only your tax bill for 2017. It was a one-time offer. It's like the guy that flips the sign and sells you a mattress on Mother's Day, right? Just today is what the tax committee staff were writing into the provision. And that's part of why we didn't see this problem of flowing down to dividend receivers of Google. You know, Google didn't do a dividend then, but any of these other companies.
And it was specific to the Moors because they were investing in a company that was selling in India. Right.
So they invested in a company that is established in and operates in India, and it's privately held.
And there are two
That narrows the pool of people who are affected.
two important facts. They had to own 10% of the stock they did. And the overall stock ownership had to be 50% US citizens, right? That made it, yeah. Right.
And the corporation itself has to not be a US corporation, it's some other country.
Right.
Any other country.
Right. So I want to take another step back because I ran some of this by my wife last night and she's a doctor. So she's like way smarter than me. And I said to her, I said, well, what's the case deal with? It deals with unrealized income. And I was shocked when she said, what's that? Right? Because like we've been, I'm no CPA, in fact, as a lawyer, I hear about this, but just because others may not really have that firmly in mind, what's realized and unrealized income, and that's really at the heart of this, Tommy.
Sure. Well, I was
Definitionally.
more like your wife. I think you being a bankruptcy judge might have been more into that.
No, we had no income.
Okay. The opposite.
That was never part of the deal. Go ahead, yeah.
Yeah, I honestly had barely heard of the term either. And one of the interesting things, you learn a lot about a case in a specific way of trying to write a brief for it because you pick particular words and language. So one of the things we emphasize at Cato is we try to write briefs that non-lawyers like your wife can understand. And so when I was working with our outside counsel at Fenwick and West, I was saying, you know, what synonyms can we use for realized? Can we just say received? And they would explain, well, it's close to that, but it's not exactly that because there are some situations where you get a benefit, but you didn't really receive it. So a classic example is a dad buys a bond for his son, and when the son turns 18, it vests and the son gets the benefit of it. You can tax the dad because now the gift he gave has now kind of blossomed. He's given, someone else has gotten the benefit of it, but the point the dad was trying to do was give a gift, and now that goal has been satisfied. So there's no one single synonym that captures every facet of realization. If there were, this would probably be an easier case. But in general, it's being either directly receiving, getting some other benefit, seeing someone else directly receiving it, or having some control, getting a new kind of power over something you didn't have before. So one example is partnerships, which is the sort of even more closely held than corporations. The income that comes into a partnership can be treated as the income of each of the partners because of the notion that it's really just another way of saying that it's their income. And one of the things we'll get into in this is one of the controversies that the Supreme Court has never explicitly kind of laid out is, okay, what about not partnerships, but corporations? When can income that comes into a corporation be treated as income coming into its stockholders? Whether you want to call that realization, or whether you want to say we don't need to call that realization, but it's still income anyway. But thus far, the Supreme Court has never explicitly endorsed taxation, income taxation, when there has not been realization. And that was the line that the Ninth Circuit crossed that got a lot of people's attention when they said explicitly, no, there's no realization rule. Now, it is true the word realization does not appear in the 16th Amendment, but one of the debates in this case was, okay, at the time, what the dictionary definitions of income generally refer to realization, and a lot of them did.
Yeah, so I want to pause on that's really important, what you just said a lot. And one of the things you said that is shocks the conscience in a way, to me anyway, is that the Ninth Circuit says there is no realization rule. And I agree that I've been looking at that 16th Amendment a lot in the last few weeks getting ready for this, and I don't see the word realized in it, right? I don't see that in, but the Supreme Court, you have said, have heretofore, actually heretofore, including now, I mean, we haven't heard them, what they're gonna do yet with more, but has said, we tax realized income. So you get the money and then you pay a tax on it. Not that it's unrealized, you can't get your hands on it yet, but you pay a tax on it, right? That's the simple kind of approach to this, right? Can you tell us what happened here? They sued in the district court out in, I think in probably Western Washington, right?
Yeah.
In Seattle, and right, lost to it by a district judge. Went to the Ninth Circuit Court of Appeals, which would be San Francisco, went to a panel of 3, lost again. The Moores lost again. But tell us what the basic, that's the travel of the case, but what was the gist of what the Ninth Circuit said here?
Yeah, so the Ninth Circuit looked at various Supreme Court precedents. They looked at mostly the precedents that I was mentioning where you have realization but not direct receipt, the things like the father's gift to his son, vesting, or the partnership, income to the partnership being treated as income of the partners themselves. And the Ninth Circuit interpreted those cases to basically get rid of a realization requirement, if there ever was one. And it's true the Supreme Court hasn't always been super explicit about, they don't always say one way or the other, we are imposing a realization rule and that has been met here, versus, no, we don't need to find realization here. And that's one of the big disputes here. Ninth Circuit's interpretation was that those cases of the Supreme Court were not imposing a realization rule. They were imposing a much looser rule of basically any income that you kind of have a connection to in some way, or some sort of benefit to a thing you own. And so they really relied a lot on this analogy to partnerships, and they also relied a lot on a law called Subpart F, which this is technically the MRT is part of Subpart F, but it's easier to kind of treat it, the older version, as its own distinct thing. And in some ways that mechanism was similar. The key difference was it was 1 year at a time. So each particular year that an owner of more than 10% of a foreign held corporation could be taxed on the income of that corporation, on the notion that, okay, you held a certain amount of controlling stock over the course of that year. As that income was coming in, this company that you have some control over, now you potentially have the ability to do more things with it, because the thing you control is taking in income. So Subpart F has never been upheld by the Supreme Court, but it's been upheld by some circuit courts. And the Ninth Circuit endorsed those others and basically said, when it's been challenged, it's been unanimously upheld. And this is pretty close to Subpart F. The biggest difference is it goes back 30 years instead of going back 1 year. And so they said, on that analogy, we're not going to upend. They basically said, if we struck this down, you'd have to strike down Subpart F2. They can't be meaningfully distinguished. We're not going to risk upsetting the apple cart. So instead, we're going to uphold this.
Right, so in the tax code, Subpart F says that certain kinds of income, even though it isn't realized, if it's earned abroad, right, similarly, it can be taxed. So it's unrealized, but
Well, that's in dispute. I would say the Moores argue that you can plausibly call that realized income because it's more contemporaneous with when they're holding
because
it.
of the contemporary.
So this
Yeah.
gets to, it's in the weeds, but it might be interesting. We actually made two constitutional claims.
Mhm.
And Tommy just explained why the second one came into play. So there's the claim about realization, which is very important. And that's the distinction between a capital stock and a capital flow, right? You can't have income unless there's a change of status, a flow. And the other was a constitutional claim about abusive retroactivity.
Mhm.
And the way subpart F has been written and interpreted since the mid-1960s is that it's only 1 year at a time.
Mhm.
Whereas the 2017 tax law had a 30-year reach back.
Mhm.
And so that phrase about abusive retroactivity, the High Court has found in the past, that's a no-no. And that's why we made this second constitutional claim to give them an opportunity, as many opportunities as possible.
Is that a due process concept that you just described? I mean,
I think it might be out of the Fifth Amendment, takings, but I don't know.
In the appellate court, they did explicitly make a due process claim, but now it's hard, the Supreme Court kind of uniquely, they get to take cases, but they get to only take parts of cases if they want to.
Right.
So they take particular questions.
Right.
And I think strategically, it made sense to kind of narrow this down to the most consequential question. So on the strategically, the
identified
Moores
the issue.
narrowed it down to just 16th Amendment. So this retroactivity is still very much a key part of the argument, but it's now only what consequences does the retroactivity have to the 16th Amendment question is the only thing at the Supreme Court level currently.
as a retired federal judge, I have to say that if I could have cases come in and I could say, well, you know what? I don't like that part of it. I'm not gonna decide that. So I'll decide this part, because that's of interest to me, anyway. I won't bellyache too much about that. So you guys went to the argument, did you?
I did not.
You did not? You've listened to
I
it?
listened to it,
You
yes.
listened to it?
I did.
You did go?
I sat there with Kathleen and she was very fidgety.
Oh, that's good. That's good that they went. That's a powerful moment.
It was cathartic for them. I mean, this has been a hard road for them.
I mean, to hear your name, called, Moore versus US must.
And especially in the basically since cert was granted, and then
Yeah.
8 months prior, they've been dragged through the mud.
Mhm.
I mean, that's part of our contemporary high stakes legal world is everyone gets attacked.
Mhm.
Members of the court, members of the bar, people that bring a claim, and I can't be more plain to say they're just like you. They're just like your neighbors, and there were claims made about them anonymously in the press about what they misrepresented to the different courts and all these things, and it was a very cathartic moment to hear their name called and watch someone advocate on their behalf, to see it happening, unfolding. So.
All right, let's go to the next slide. Caitlin, I need to be aware of time. What are we doing for time?
We're about 7.
Meaning, how
We're
much
at 7
time
o'clock,
left?
so about 15, 20 minutes.
15, including questions? To be honest, it's okay. All right.
We should wrap up around 7:20.
All right, so, but I want to do this, because I think it's really it's important to me to hear this. I think attendees would be interested in it. So Cato is a powerful voice, right? And you're making decisions on what cases you're gonna take and then what arguments you're gonna make. So Tommy, could you, a couple seconds on how you decide? And second, in this case, why did you think this is something that the Cato can have an influence on?
Sure. So as I said, I'm definitely not a tax lawyer, and we're very much generalists at Cato. We're a small crew, and we're focused more on constitutional issues. So our angle always is, how can we describe this kind of a generalist way? The justices themselves are generalists also. They're not deep in the weeds of the tax code necessarily. So you want to make the broader stakes of the case more plain, both to justices and to non-lawyers who are reading it. So I didn't want as much, some folks focused on, the 5 other parts of the tax code that will or won't be upended by this.
Right.
That's not, our specialty. We're not going to possibly have expertise in that. But things about, why this original compromise mattered, why treating words with their original meaning matters. That's important to Cato across a lot of different cases. Our whole mission is basically reinvigorating the original understanding of the Constitution and its liberty protective and government restricting aspects of many amendments, including this is the first I think this is the first 16th Amendment case that we've worked on. It's one of the first 16th Amendment cases at the Supreme Court period in the last couple decades. So it was a very cool and unique opportunity to get to work on that. And it was also great to work with 2 attorneys, Sean McElroy and David Forst, for several reasons. Sean happened to be a friend of mine from law school. We graduated the same year, and he wrote, I believe, the very first law review article raising the constitutional problems with this, called very simply "The Mandatory Repatriation Tax is Unconstitutional," and people mocked him for it and said, this is crazy, this is borderline frivolous, no one will ever buy it. Well, at least 4 Ninth Circuit judges have already bought it, so I think he's been pretty vindicated in that respect. So it was great to work with him. Our brief essentially focused on a couple things. Subpart F was a key thing, distinguishing that, focusing on, how if something is just over the course of 1 year, you possibly have control over it. But this was really just a snapshot. This was no different than looking at, do you own a mansion on this particular day? Okay, you do. We're going to hit you with a tax, as if you had just sold the mansion and made a bunch of money off of it, even though you did not. So it's a legal fiction. So that was a lot of our emphasis was on that, and just on the consequences that, if you get rid of the realization requirement, well, you very much down the line could have things like a federal wealth tax, which has been raised, or federal property taxes of the type like local governments currently imposed, now suddenly imposed by the federal government, which would be a massive sea change.
Mm-hmm. So you attended the argument and you listened.
Yes.
That's, just as good, really. Although there could be some body language, I suppose, but so prognosticate, where do you, and we're not gonna hold it to you, reading tea leaves is, with all the, I'm probably dead wrong on this. How do you see the court breaking? Based on other things they might have written and maybe what was asked or spoken of at the argument.
Hard to read, I would say. The swing justices had tough questions for both sides. I think the key justices will be Kavanaugh, Barrett, and potentially Roberts as well.
All right, so the three I hate categories, but the 3 more liberal justices, they're gonna affirm.
I would think very likely. Sotomayor and Jackson had the consistently toughest questions for the Moore's side. Yes.
For the Moore side, okay, and anybody on the far?
Alito had only friendly questions for the Moores. Gorsuch was pretty friendly for the Moores. Thomas still doesn't ask a ton of questions, but I'd be pretty confident he's going to side with the Moores as well.
All right, so I'm seeing 3-3.
Yeah.
So far, so we got 3 in the middle.
Yes.
Right, the chief.
Kavanaugh
and Barrett. And did they tip their hand?
I don't know that they did. I think Barrett in particular showed concern about the other aspects of the tax code. So Part F, the partnership taxation, she really wanted some assurances, like, are we going to go down the slippery slope to have to strike down those if we strike down this? Those are the justices who tend to care more about things like stare decisis. How do we fit this within all of our different precedents? Even though that's tough here when you don't necessarily know what's dicta versus what was a holding in the prior precedents. So, I'm really not sure about the outcome. I think the attempt from the justices, as much as possible, will be to have as little, to avoid both of the parade of horribles. I think they want to not risk upending subpart F, all those other things, but also not risk saying a wealth tax is fine, go for it. The hard part would be, how do you write an opinion achieving both of those things?
All right, so now I'm going to focus you on the wealth tax.
Yeah.
It is a lot of interest here in Massachusetts because we think we call the millionaire's tax of, a couple of years ago, a wealth tax. I'm not certain it fits the description 100%, but first of all, what's a wealth tax? And secondly, is there any outcome of this case that would affect one way or the other the ability of a government, state or federal, to impose a wealth tax?
Well, the first easy question is we're only dealing with federal here. So this is all, everything related to the 16th Amendment is only a limitation on the federal government. In terms of what can a state can do, that's up to what's in the state constitution. So there's no other, so a state, sorry, I can't help you if Massachusetts constitution allows a wealth
Fair
tax,
enough.
they
Okay.
still could.
All right.
But in terms of what can the federal government impose, a lot will depend. To get the solicitor, it could be just literally how much, what are your assets? You own, $10 million house, you own such and such, all your total assets are $100 million. We're gonna pick an arbitrary day of the year on December 31st, total number of your assets, you owe, a
3%.
Yeah,
Yeah.
could be anything, yeah. We treat it as if you sold everything and made a capital gains off of it, even though you did not, because that's
And
pretty
it's-
analogous.
It's worth, just to interject.
No,
Yeah.
momentarily, yeah.
At issue in the case are shares of a company.
Yeah.
So it's not just your home or your automobile or your wardrobe or your art collection or the lawnmower you have in the garage. It's your portfolio.
Mhm.
So it's a snapshot of your portfolio is what Tommy's describing.
Yeah, and I think the Solicitor General certainly wanted to narrow the case, so she really focused on, well, no, this was about income that came into a company, a corporation, so the corporation at least realized something. So if we can just limit it to that, then that's different from your mansion, because mansions don't make income neither in over 1 year or over the past 30 years.
Right.
Again, if you can spin that against them. You can say, well, they still appreciate, and that's kind of analogous to Kisencraft making earnings over since 2006 or whatever. But that's at least the line that the government wants to attempt to draw, is that this is like taxing, what did your partnership make? Or what did your S corporation make?
Yeah, there's a really uncomfortable for the Solicitor General moment late in the argument. This point that Tommy just described came up. And she is, I'll just say, she is best in class, right? Our current Solicitor General is the top 0.5% of advocates out there. She's really good. But the justices were saying, Gorsuch especially, what you're describing here, these narrowings, this limit, that's not in your briefs. You didn't brief this to us. I can't find it anywhere. It wasn't in your briefs for the lower court. Why are you bringing me this now? Because I can't really consider it. And it was very uncomfortable for the government to say, well, I understand that the people that I'm trying to persuade, the 9 of you, want to find a path that creates bounds. And she was trying to help them create those constraints and bounds. She couldn't do it because the government's argument had been, do not tie our hands in any way, in any shape, fashion, or form. And that was, it was telling, because it really, there's a little bit of motivated reasoning here, I'll admit, but it really took the logic, not the emotional appeal, but the logic out of the strongest arguments from the bench in the form of a question from Justice Sotomayor. And she was really strong, during the arguments. But that moment mattered, I think.
The ironic thing is that they didn't beat the benefits of the asset yet, but they're being asked to pay the tax. But on the other hand, under our current code right now, if they borrowed against the appreciated asset, they're not gonna pay any tax, but yet they effectively did reap the yields. Right?
That falls under the category of, we had a really good fact pattern.
Well, not only that, but what when you come to the Supreme Court with a case like this, to come with people like this, who were trying to help the most indigent people maybe on the planet, that's a pretty good look, and then you tell me, and I'm chagrined to hear it, I really am, that there were people attacking them personally. That really is beyond the pale. It's sort of beyond belief almost, but yes, so we have a few more minutes. I want to open it to any other questions. Yes.
Curious when you talk about the division of the justices. Used to be 100 years ago, a lot of justices were deeply steeped in business and tax law themselves. Are any of the justices now having that background? Are they all administrative and constitutional aspects?
Well, this is the editor of the Supreme Court.
Yeah.
Uh,
Who are these people?
I might suggest, they profess, they tell us so. They will each say, I'm not a tax expert. They say that in the lectures and things that they give, you know, kind of in the off season. I think your point is very well made, though. Some of them have more experience with commercial law than others,
Which
right?
ones?
I put the chief in that context, but it's, you know, it's 20 years in the rearview mirror. But still,
But it's something in the
Yeah.
rearview mirror.
Yeah, that's the only one. He's really the only one now on the court with significant private firm experience, kind of shocking.
Right.
All the others were mostly either in government time or academia.
But the other thing that we're missing, I think, on the court, and you'll tell me, but do we have trial judges? Did any of these folks sit on trial bench where they would have seen lots of cases, including lots of commercial?
Two, Sotomayor and Jackson were district court judges. Sotomayor in New York City and Jackson in the DC circuit. But DC obviously is gonna be more still governmental, so.
Administrative.
Yeah, so Sotomayor would have by far had the most business law in a trial court setting experience.
Right.
And that probably came out in the argument. She was probably the most active questioner in the arguments.
And did any of them go to a law school that might have actually not been among the top
Mostly
three in the
retired
United
international
States? and
tax
therefore
lawyer, who
invited
spent my whole
you know,
career, 50 years
did-
plus,
Only
They're
one
all
being
Harvard, Yale.
subpart F,
She's Notre Dame.
She's
foreign
Notre Dame.
companies, et cetera,
Right.
basically
There
what
you
we're
go.
talking about.
Well, that's diversity.
And I was just,
Frank, we have a
I'm very
question from
interested by the
online audience,
concepts
if
that
I
we're
could.
discussing,
Skip,
and I
if you wanna
obviously
unmute and
cannot
ask your
speak
question.
for the Supreme Court or where they're gonna come out. But a couple of things in perspective, the foreign personal holding company rules where US is taxed income of foreign companies set up by US individuals, been around for more than 100 years. Back in the early 1920s is when this first came out. So the concept of taxing the income of a foreign company that has not been received directly is pretty old and cold. There has been this anti-deferral concept that came up basically in 1962, as we've alluded to subpart F already, which was saying, okay, you've got a foreign company, if it's controlled by US shareholders, then the US can tax the income of that company currently. And then they said, but we won't. This goes back to JFK in those days. They said, we won't tax it unless it runs afoul of the foreign personal holding company rules or the subpart F rules on a current basis, which we've already alluded to. So that goes from then to now until 2017. I mean, to our Tax Cuts and Jobs Act, all that income was accrued and built up overseas by these controlled foreign corporations. We were up to about $2.5, maybe $3 trillion worth of income untaxed. It was pretty broad exceptions. The subpart F rules are pretty easy to stay out of and not getting into trouble. But many, many taxpayers, not just the two that we're talking about here, over the years ran afoul of the CFC rules. Thousands of small taxpayers. We're not just talking about the Microsofts and the Googles and everything. Virtually every company in the United States that had a foreign operation was subject to these rules, but many of them were accidental taxpayers, but they nevertheless ran afoul of the rules. So the concept, of course, we've talked about realization, but I think of it as constructive receipt, that the United States does not and cannot tax the foreign corporations, but it can tax the shareholders of those corporations, which is where we are here. So it's a concept of constructive receipt versus a realization, but it goes back to what you just said. We're talking about the income of the company, not the value of the company or the shares per se. So I think all of it comes down. I mean, I find it hard to imagine that the Supreme Court will come up and say, oh, I'm sorry, this is going to be taxed. You can, we're not going to allow this current taxation of this income because it wasn't realized. On the other hand, the retroactive part is pretty new. And it's interesting that virtually all the companies I've worked with and were keenly following all of this at the time, nobody came up and said, this is not going to fly, that we're going to go back and challenge this as non-retroactive or as having been retroactive. So, and I've kept my finger on the pulse pretty well over the last few years. And in fact, also advising companies on how to bring back the cash. And we're talking by the end of it, I don't know how much finally came back, but probably on the order of $1 trillion or $2 trillion. So that's going to be the interesting thing. I'm not optimistic that the Supreme Court is going to throw out the whole baby with the bathwater. They may try to come up with something that carves out an exception. I can't imagine that they would say the retroactive thing is not going to fly. So more likely it's going to be trying to come up with something that would find a happy solution. I'm not optimistic about that either, but those are my thoughts about all of this. It's very interesting to hear you guys discuss it.
Well, I'm speaking as a complete novice. These guys actually have a level of expertise, probably not practicing international tax law for a number of years. So we thank you for your observations. That's really helpful.
You're welcome. Thank you. And you're in really good hands with Fenwick and Welch, by the way, a great firm and highly experienced in this area. So if they're on your side, you're in good hands as far as it goes.
I'm sure that they're happy to hear you say that too.
I'd be interested in
yes.
views. If the court were to seek a very narrow ground on which to find favor in Moors, what do you think that narrow?
That's a great question. Do you guys have a thought on that? How can they get? Yeah, if they're trying to get out of this now. Yeah,
something that's half formed in my brain. So the Moors have no control. And when you think of ordinary circumstances, you think of the parent U.S. company with a sales subsidiary in Ireland. So the parent controls the subsidiary. You haven't even gotten to the third tier, which is the shareholder of the parent. So the shareholder of the parent has no ownership interest in the Irish subsidiary. So you take all that off the table. I don't know how much subchapter F gets taken care of in that. So I'm wondering whether a narrow ruling based on the circumstance that I assume this was not even debated before the court, they have no control. They have no power to compel this company, even if they wanted to get dividends, for them to distribute earnings to them.
I might add that the problem with that is that all the controlled foreign corporation rules are based upon shareholders who own 10% or more of the vote or value of the stock. So that's your first target. And you say if all those together own more than 50% of the stock, then that's deemed control and therefore puts that corporation in the purview of the subpart F rules. However, there's a simple case. The Intel owns 100% of its sub in Ireland. It controls it, can do what it wants, and force them to pay or not pay a dividend when they want. In many, many, many cases, there is no real control. It's all deemed by the 10% shareholders who may or may not know each other, may or may not coordinate with each other. They really cannot compel anything in many cases. I mean, the big ones always get everybody's attention, but there's the real world out there, Main Street taxpayers who have foreign corporations who really don't control anything. So I'm not sure how far that would go, but it would be a nice approach. And then send it back to Congress and say rectify.
It's always the 10%.
Well, I think
go ahead.
One area to narrow a route. Generically, I am not a prognosticator, and I've put too many years into this to be anywhere near unbiased. But I think
you think the Celtics are going to win. Never mind.
I'm a Cubs fan, so that says enough.
All right, say no more.
I think we have about 4 ways to win, and 1 way to lose. Two ways to lose. So a second way to lose, I don't think will happen. It's very unlikely, based on the fact pattern of how we got cert, that they would send it back to the 9th Circuit. I think they took it because they want to decide something. But if I'm wrong on that, there's a second way we could lose. We could go back to the Ninth Circuit, we could get a bad ruling there 2 years from now and be done. But there's about 4 ways we could win. And one way to kind of narrow this is just to say, as it was briefed and argued before the bench or before the court, that this is severable from the rest of the tax code. This is not about subpart F. This is not about S corps. This is not about partnerships. This is not about all that other stuff. This is about a couple, right, that invested in a foreign company. And then the second step of that logic of how they would have a narrow ruling, I think still gets us in a good place from my policy instincts about shutting a window on a wealth tax. The court can rely on, Tommy did a great job explaining like how the court has not handled realization. What the court has done in the last 100 years in different places and inconsistently, they've done it differently in different cases. What is income, right? And so these 3 elements, access, realization, and dominion, I think a narrow ruling would say these people had no dominion. The point that Mr. Patton was making, they couldn't decide whether to make dividends, pay interest. They couldn't do anything. So they failed. You fail the test, you can't tax them. You can't claim this money from them, and that would be pretty important. That'd be a pretty important way. And I from the questions and the argument, that's how I think you get Kavanaugh. You bring them right in with that. Barrett, I think you bring in with the severability, you know, because she was really worried about like, well, tell me about this provision and tell me about that provision. So
Do no harm. One last question. Anybody?
I have a wild prediction.
I thought you were not a prognosticator.
But
Brought you along.
you brought me along. I'm gonna put it at like 2% chance. And by the way, nobody involved in our legal team thinks that this has a chance. They think I'm crazy, but I'm the only non-lawyer.
Yeah, you're not burdened by a legal education.
And I told Frank this earlier in the week. I think there's a very slim chance that this could go 7-2. And Justice Kagan could come along if they sever the question and then make it mostly about admin law. Justice Kagan, she's great on some of those questions. And the chief loves to find a way to work with her. And I don't know about you all, but I remember when the chief got it wrong on a major question that was not a tax case that he found a tax. And this would be a way for him to not walk that back from 2015, but get on the board on a tax question and bring along Justice Kagan.
I think we need to move people along. I want to end with this. I thank these guys very much for coming up here to Boston. This was an incredibly informative and important discussion for us to have. But I want to focus on this with the last word, and that is without public interest entities like CEI, like Cato, like Pioneer, this never gets there. This case never gets to where it is today, right? So this question never even gets asked because nobody's going to, for $14,800, they're not doing it. So it's incredibly important that, you know, that we continue as best we can. And I thank you guys for what you do.
Thank you.